Governor Sarah Sanders has officially made the call for our special session that is set to begin Monday. Robert Steinbuch, attorney and member of the Arkansas FOIA Task Force, is here to talk about the bill that is set to be filed. Actually, it is filed. That is House Bill 1003, and that is about our Freedom of Information Act. Hi, Robert.
Hey, Jenny, good to be with you again.
Absolutely. Well, Governor Sanders talked about that FOIA bill. She said it is ultimately about the security of her and her family, but there are also elements of that bill that is raising a lot of eyebrows. I want you to talk about that bill with us today.
Happy to do it, Jenny. There are four sections essentially in the bill. They're broken down into more subparts in the actual bill.
Yeah.
Conceptually, there are four sections. One is about the security for the governor and her family. And we all agree on that.
Yeah.
She should have all the security. And the provisions regarding the security for the governor are just fine.
Yeah.
Now, there's a little bit of language in there that suggests that they're also going to close off records about expenditures. And I'm not sure that makes any sense. But let's not get into the weeds. The sections about the governor's security are just fine. But there are three other parts, and they're highly problematic, and they have nothing to do with the governor's security. And if anybody tells you they do, they are gaslighting you. That is not true, because the next section is what's called the deliberative process privilege, which they only apply to the state. And I'll come back to that point because I think it's interesting. They say any records of any agency when they are considering making a new rule are off limits forever. So you never get to see how the sausage is made. And then they put out a new rule and say, here it is. And then you could FOIA the new rule that they just put up on their website, of course. So there's nothing left to FOIA, because the only thing that's left from that whole process is the very thing that they put out, like Caesar decreeing a new rule. Here's the new rule. How did it happen? We're not going to answer that. What lobbying groups were involved? We're not going to answer that. Who sent letters in favor and against? We're not going to answer them. All of that would be exempt. So that's not oversight at all. The next section is what's called the attorney-client privilege, and they break it down into two parts, by the way, and it's rather interesting. And in those two parts, they say that records that an agency has dealing with attorney-client communications are all off limits. I call this the Rapist Protection Act, because you will remember that Jerry Sandusky raped a bunch of basketball students that he was a coach for at Penn State, a state institution. And they got wind of that early on, and they brought their attorneys in early on, as they should, by the way, to figure out what's going on and fix it.
Yeah.
And when there were a bunch of FOIA requests made, guess what? They didn't turn over the records. And why didn't they turn over the records? For the very exception that this bill seeks to impose here. So that's what the proponents and the authors of this bill seek to do. They seek to bring the problems of Jerry Sandusky into Arkansas. And we've seen things like that at the local level already up in Fayetteville. I had mentioned to you, by the way, this only applies to state actors. Now, why is that?
Yeah.
They might say, well, we're splitting the baby, you see. We're not being as aggressive on the Freedom of Information Act. No, that's not the right interpretation, because either it makes sense or it doesn't make sense. And if it makes sense for everyone. But what you've done is not seek to have something that benefits government because it's good government. These folks have simply sought to carve out the actions of the state government because they can. It's a pure exercise of power. And so they don't care about protecting the counties or the municipalities under their theory that it's necessary, because it's not about being necessary at all. It's about power. It's about merely the exercise of power. In fact, if you look it says under this attorney-client privilege, one part says prepared by an attorney, and that's of course an attorney-client privilege. And then another section says records created or received by an elected or appointed state officer, state employee, or state agency, board, or commission that would be privileged under Rule 502 of the Arkansas Rules of Evidence. Meaning, it's not only attorney records, it's a whole host of people.
Wow.
You just heard me list them.
Yeah.
Elected or appointed officers, state employees, state agency, board, or commissions, all of that is carved out. That's how huge a path this is. And now finally, they have a section that they changed the standard on attorney's fees.
Yes.
Now,
That's section 5.
right. And they say now remember, a lot of these folks that are the co-sponsors of this bill are also advocates and have been on bills for so-called tort reform. And what's the key component of tort reform? It's, hey, the loser has to pay.
Right.
That's the rule in the FOIA right now. The government has to pay if it loses, plain and simple. They want to change it. No. If the government loses, but you don't prove that they acted in bad faith, you as the requester don't get your fees. So these so-called conservatives, they want loser pay for everybody but the big bad government. Isn't that remarkable? They create a protection bubble for the government that they're unwilling to provide for private individuals, for you and me, but they provide it for the government. It's really remarkable. I've handled many FOIA cases, mostly without litigation. I've advised people, I've advised government entities, I've advised individuals. I got brought on 1 or 2 cases with Joey McCutcheon, who of course you have on your show and you know well. And when he won those cases, he got an order of attorney's fees. And since I worked on it, I got a small portion or a relative portion, a perfectly fine portion. And I'll tell you this, when I put in my request for attorney's fees, I'm so modest, not about myself, but in my request for attorney's fees that I said, in the private sector, I ask for $1,000 an hour. Now, I haven't taken on paying clients in a long time, but I ask for $1,000 an hour. What do I ask for the government? Nothing of the sort. I said, give me whatever he gets. And you know what Joey was asking for? $250 per hour. So I got a couple few $1,000s. You have to win your case. You have to substantially prevail in order to get attorney's fees. That's the only circumstance in which it occurs, and it's modest. It's $250 or so per hour, which is not a significant fee. And they want to turn it around and say, nope, basically you don't get that. Now, I don't care about collecting it, but because I don't make a living doing these cases, I make a living separately. I do these cases for the people of Arkansas. But it's really remarkable that the very standard that these conservatives want to apply in tort reform to you and me, if we get injured, they don't want to apply to the government. It's called a double standard, and it's something that disgusts true conservatives, double standards. We always call out the liberals when they have double standards. Here is a double standard by conservatives, or at least the Republicans on this bill. I'm not sure I'm going to call them conservatives right now.
I think a lot of viewers would agree with you. Help us understand why this bill is now filed, why this is happening during the special session. I think anyone would agree and understand if this were about the governor's safety and the safety of her kids, we would understand that and we would want that. But why not have that be a separate bill? This is just hard for us to reconcile all of the things that you just listed. That doesn't seem to be part of the safety component.
No, it's like the old, what's the kids magazine where they say, which one of these doesn't belong?
Yeah,
right?
One of these things is not like the other.
That's right. One of these things is not like the other. We have this section on the governor's security. That's perfectly good section, maybe with a tweak, but as a general matter, perfectly good section.
Right.
And then we have this deliberative process privilege, the attorney-client privilege, the change in attorney's fees, those have nothing to do with it. That's a grab bag by bureaucrats who don't want to be accountable to the public, don't want transparency, and got their claws into what otherwise would have been a perfectly reasonable bill to bring during a special session. You don't make these other kinds of changes, frankly, I think, at all. But if you do it, you don't do it during a special session.
Right.
That's undemocratic.
Right.
Right.
And then have any of you on the FOIA task force, have you been contacted? Do you know if any of you on the task force have been contacted?
To the best of my knowledge, nobody on the task force has been contacted about this bill.
I know that also a point that was mentioned during the press conference was that a Chinese-owned company could use our FOIA law to gain access to sensitive government documents. What say you to that?
You know, it's hard to unpack such an incorrect statement. First of all, you have to be an Arkansas citizen to make a FOIA request. Second of all, if they're worried about competitive advantage documents, there's an exemption for competitive advantage. So what kind of documents don't fall into the competitive advantage exemption that they're worried about, right? So this is the kind of scare tactics that I don't take kindly to, because they're just throwing stuff. Well, you know, someone can make a FOIA request for nuclear codes. No, they can't. And by the way, nobody in state government has them, right? But it's as ridiculous. No, the Chinese government can't make FOIA requests. They even if they got someone to act as a proxy, they couldn't get competitive advantage information because that's explicitly exempted in the FOIA right now. So it's simply not true. And I don't know more how to address kind of made up excuses. I agree with the governor. Her family's security is paramount. Mm-hmm. And I agree generally with the provisions in this bill for her family's security. And if this were if only that part were submitted, I might not even testify. And if they break it out into a separate section, I likely wouldn't testify. But then there's this grab bag of protect the bureaucrats and remember the Rapist Protection Act, because that's what's in this bill. Someone is going to get molested and it's not going to come out. Why? Because of this bill. And that's going to be on the shoulders of these legislators.
Our regular session, General Assembly, was not that long ago. We were just in session, and I may be way off on this. I'm wrong all the time. My older kids can attest to that for sure. But if the safety of our governor was an issue and has been an issue, it seems to me, and then with the retroactive part of this bill, why wouldn't that have been maybe brought up during that legislative session rather than trying to cram that in now in this special session? That to me, maybe I'm off. What do you think?
Well, let me turn it around.
Okay.
Maybe they got delayed. Maybe they didn't think about it enough.
Sure.
And maybe it is an emergency so that it needs to take place during the special session.
Yeah.
Meaning that's when a special session is proper to bring up something related to the FOIA in an emergency. So let's assume, I am agreeing, no less, that what the governor says about security is true. Okay, maybe they missed their window last time, bring it up now. But it also highlights the absurdity of the alternative. All these other sections, there's no emergency about them.
Right.
It's just about political convenience. And the evidence that it's only about political convenience is that this bill only applies to the state and doesn't apply to the localities. I'm not looking for it to apply to the localities. I'm looking for it to apply to nobody. But you can't make a consistent argument that this is for better government, but only better government for the state. So you're only for better government of the state. The claim of efficiency rings hollow. And remember, the thing about efficiency is government can be more efficient. They're usually totalitarian when they're more efficient. So let's not be so in love with this notion of efficiency when the price is transparency.
Right. Regarding government efficiency, there were several questions about, what will this look like? And, regarding the deliberative process and, will we be able to see agencies making recommendations? Say, will we be able to see budget recommendations? Will we be able to see, recommendations regarding, say, if, Department of DHS, if they make a shift? And you just couldn't really get a clear answer. You couldn't get a clear picture. And I thought it was really telling with some of the questions from the journalist. And finally, someone said, what do you think the public has a right to know? And, that just, you could really get a clear sense of, we don't know. We don't know what this is going to look like coming out of it if this bill passes.
And that shows you why this should not be done during a special session.
Absolutely. Anything else that you want to add, Robert?
No, that's it.
All right. Thank you so much. As
you so
this
much.
starts moving through next week, we would love to have you back on.
I'll do it. We'll do it.
All right.
Look forward
All
to
right.
it. Thanks, Ginny.
Thank you so much.
Bye-bye.